All right, so what is your, and this is mid-June, right, is when the trial is going to start?
June 14th.
Yeah. And is your sense that, see, now this goes to exactly what he was saying to us, too. He was talking about preparation, and he was leaving us with the impression that the preparation on your side, not his and Leonard's side, not he and George, not Andrew Abood and George Leonard, but on the Brodsky side in your firm, he was leaving us with the impression that that your styles of preparation were different, and that those guys were ahead of you in preparation.
Oh, absolutely not. As a matter of fact, George came in only, I think, about 2 months before we started the hearsay hearing. I had been on the case for, almost a year before that. So we were all very much up to date. Lawyers, all criminal defense lawyers, all trial lawyers have different styles, and some think that the minutiae are what's important. Some think that the big picture is more important. Some think that cross-examination is the end-all and be-all, and some think that simply the way you argue to the jury and present and the storyline you present.
Joel, I see you as a big-picture guy.
Well, that's actually, to some extent, that's the job of the lead attorney. You're kind of like the coach, and you set the strategy, and then you send your star players out to execute. And that's kind of my job here as chief legal counsel in this case, is to set the big picture strategy, to assign out different jobs to different people, and let them execute. And I've had some very great lawyers working on this case from time to time, and they've executed very well. But when I set the big picture and I set the strategy, that's going to be the strategy, and I discuss it with the people that work with me without question. And if they can agree, that's great. But if they're unable to agree and they feel very strongly, I guess they... Here's basically the net. Don't you love that term, the net of this? The triple net.
The triple net is this, that I think Mr. Abood was trying to tell us in his elliptical way that the Will County State's Attorney has been working on this case, obviously, since day one. They are. It was my sense, is what he was saying, is that they are motivated and well prepared for this, and he was concerned about the level of your preparation in this. And so you're saying that. Are you concerned at all about their level of preparation? Let me ask you that.
Well, I wasn't very impressed, to tell the truth, with the presentation that they made at the hearsay hearing. They've had at one time 100 police officers and agents. They had, probably a dozen attorneys working on it. Yet they didn't know day to day which witnesses they were going to call and in what order. So no, I wasn't all overly impressed with their preparation. Of course, once again, it wasn't the end game. It wasn't the real trial. It was this hearing on evidence.
But it was a trial. I mean, we talked about this before, Joel. It was a trial before the trial of Drew Peterson.
Well, it was to some extent, but I think they were as unaware of what their witnesses were going to say to some great extent and how their witnesses were going to perform as we are before we cross-examined these people. They were preparing for witnesses the day that the witnesses, they were prepping witnesses the very day those witnesses were going to testify. So if you were saying, am I worried about them being over-prepared? No, I'm not. Not at all. Do I think that they're going to try to present and going to put a lot of effort into presenting a case? Well, they're going to put a lot of effort in it. The problem is that they don't have a case. There's no evidence.
I think they're going to say your client's guilty, by the way.
Well, I probably think they will, but they won't be able to put any evidence to support that allegation. And unfortunately for them, anyway, a mere allegation doesn't convict somebody. Only evidence does. And the problem of their case is that there's no evidence. All right.
Joel Brodsky. And now, thank you very much. That is correct. Joel Brodsky, and the case goes June 14th. It's going to be. There are no. I can't remember the cameras. There's no cameras for this, right?
No, just great artists. But it's going to be myself and Joe Lopez, Joe the Shark Lopez, and going to be a third lawyer joining the team. But I guess a player to be named later. We're talking to a couple of people.
Why do you need a third guy for?
Well, there's a lot of forensics in this case.
So you're looking for a science lawyer?
Yeah, I'd like to get somebody that knows that is what you said, a scientist/lawyer to.
But isn't it late in the game here to be doing that?
No, not at all. We've done all. We have all the reports. We have all the evidence. We have the opinions of our experts all done, ready to go. All our experts are in agreement. So I don't think we're all late. As to Joe, like for example, Joe Lopez, I asked him, Joe, is 60 days going to be enough? Or I've been talking to Joe for some time, but and to actually see the evidence. And Joe said that, for example, in the family secrets trial, he didn't get to see the statements of the witnesses that the government presented until less than 30 days before the start of the trial. So he said he has more than enough time.
So he's a speed reader. All right. Well, now this is going to be interesting because they always talk about. I'm a little conflicted about cameras in the courtroom, especially were they to be present in Illinois because of the flamboyant and sometimes over-the-top behavior of attorneys. But I will tell you this: if there was ever a trial based on the attorneys, not the case, because the case is horrifying and depressing, but between Joel Brodsky and Joe Lopez, that is a reality show. That's a road show right there. Good. Those are two guys you definitely want to see.
Pay to see, huh?
Yeah, you'd pay to see. They should charge admission. All right. Joel, thank you very much. Appreciate your time.
My pleasure.